welcome back to the channel. So coming to you straight after a premiere, I also have with me Mr. Robert Shaw. If we can bring Mr. Robert Shaw in. It's on screen 4, not screen 3. How are you doing, Al? You're here.
I'm doing very well, yes, and really looking forward to this. We're going to be talking about a defamation trial, celebrity defamation trial. Boo, boo. No,
really?
No,
well, hopefully we'll just we'll give it a moment for a few of the guys and gals to come over from the previous stream. Live now in the old chat for the new link, and we'll just give it a moment for others to pop across. 200 of you have come across now. So sit tight, everybody. Smash that like button while we're waiting for others to join us over from the premiere. And whilst we wait for that, an outline of this case and what you wanted to talk about, Al, so everyone isn't just sitting in silence staring at our at our faces with nothing interesting.
Okay, by way of background, and a lot of people may already know this, especially our American viewers, but there's a guy called Alex Jones, and he runs sort of online videos through an organization called InfoWars that appeal to, shall we say, the more conspiracy-minded sorts of people.
Indeed.
And after the Sandy Hook shooting, he ran a lot of broadcasts that were suggesting, or people were on there suggesting, that Sandy Hook was a hoax, had never happened, and that parents were so-called crisis actors, there were no dead kids, etc., etc. A number of the parents have sued him for defamation because, of course, they're saying they were getting harassed online, they've had physical threats, they've had people shooting, taking pot shots at their house. So they sued for defamation. There's quite a few trials going on, and in all
defamation's all the rage now, isn't it? I know of another trial in defamation. I wonder what that was all about. Maybe you'll do some videos on what that trial is all about.
There's probably a gap in the market for them.
Probably, yeah. There's probably a lot of people interested in that. Certainly, it's what I've found is people seem to be interested in defamation. Anyway, sorry, Ali, you were saying.
Yeah. So anyway,
it's Friday.
The families have sued in a number of cases, and in all of them, Jones is. Because, we were talking about discovery the other day with the Vardy and Rooney case. And what happened was that InfoWars just refused effectively to comply with any orders for disclosure. Their argument was, because one of the items was, we want any internal emails, texts, etc., with you discussing the Sandy Hook shooting. Oh, they don't exist. Well, hand over your phone records anyway, and we can check they don't exist. No, they don't, we don't have them, you're not having them. So, and we'll talk about this more in another video. They were subject to judgment in default. Their defense was struck out and basically said, right, you are now, as far as we're concerned, you have been found to have committed the libel. So we'll move on to the damages stage. How much should you pay the families for this? And there are actually two phases to it. There's a general upset damages, and there's also punitive damages, and we can talk about that in another video. However, what's interesting in the trial, and this trial has been bizarre, it's got one of the best judges I've ever seen. She just treats all the lawyers like they're naughty 10-year-olds trying to bluff they didn't break something. I mean, This is going to be a case where the judge is going to impose sanctions, and it's probably going to be something like, I'm cutting back your PlayStation time. It's just real. The lawyers nearly came to blows the other day. But anyway, on the last day of the trial, where Alex Jones is giving evidence, the family's lawyer just says to him, so just to confirm, you're saying you've never sent a text about Sandy Hook, you've never sent an email? No, I haven't. And okay, says, can I just read you something? And he starts reading lots of texts from Alex Jones, producers of InfoWars, discussing Sandy Hook and the fact that they know it's not a hoax. And they said to Alex Jones, well, would you be curious as to how where I got this information from?
Well, you would think so, wouldn't you? I mean, if someone started reading out my emails that I said I didn't send or didn't have, I'd be a little bit curious as to where that came from. And we will come back to the punitive damages bit in a minute, because I think the punitive damages thing is an interesting aspect, because we don't really have that in England and Wales. We have it in a sense when it comes to costs. I think we probably could touch on that, couldn't we, Al? We've got standard costs and indemnity costs. Indemnity, just bad. Indemnity, bad. More. You have to pay more with penalties and so on. But sorry, carry on.
We also have aggravated damages here in defamation, which we can come on to because that would have been relevant to the Alex Jones case. But anyway, so the lawyer is saying to him, "Do you want to know where I got this stuff from?" And Alex Jones is obviously a bit curious. He goes, "Yeah, I got these when 12 days ago, your lawyer accidentally emailed me 3.2 gigabytes of confidential information. I have all your phone records, texts, and emails for the past 2 years."
Yeah.
By the
way, to give someone an idea, I have one email address that into which pours everything in my business because we have to keep track of everything like that. It's obviously robustly secure on actually Google's enterprise system. This is not a sales pitch. They charge a lot for it, but most robust system that they offer. And so 3 gigabytes worth of emails, that's a lot of emails. And I know because of how much storage we use, that's a lot, even for 3 years or whatever it is, especially for 3 years. I mean, you could expect the average person for 3 gigabytes is probably, for the average person, is probably 10 years worth of emails for the average person. So this is a lot of information, 3 gigabytes worth.
Yeah. And it's going to be, so anyway, they said, well, we let your lawyers know this had happened, and they didn't even bother trying to claim privilege in it. So anyway, all the cat's out of the bag. So there was a hearing the other day where they belatedly tried to exclude this and say, they shouldn't have it, they shouldn't be allowed to. Because the bulk of the trial is over now. There's just going to be 2 more witnesses about the punitive damage aspect. But what they can do is they can look at this material, and it's whether they can use it in other litigation. Can they investigate it, and then can they use it in court proceedings?
Yeah.
And also, what was really fantastically gleeful, the lawyer was gleeful when they had the hearing for the motion on this. The family's lawyer said, "Oh, can we just check that the live stream is working? Because I've had a lot of calls from certain government organisations and law enforcement that they want to watch this." Which is never a good sign.
No doubt.
So they had the hearing, and basically, right, to get onto the technical point, because this does happen. What's very reassuring as lawyers is lots of people on social media saying, this must be a conspiracy. No lawyer could be this stupid. All the lawyers are going, we need to work on expectation management. Because unfortunately, this happens enough that all jurisdictions have a procedure for when it happens.
Yep.
In Texas, and we'll come on to ours shortly.
Indeed.
In Texas, the rule is that upon discovering you've done this, you have within 10 days, you have to write to the other side and say why you want it back and why those documents are privileged. And you have to say, look, you can't have this because of X, Y, and Z. Mm-hmm. However, all that happened was that Jones's lawyers had sent an email saying, please disregard. Mm-hmm. And the argument from the family's lawyers was that doesn't pass the test. Mm-hmm. Also, Jones found out about this while in the witness box. They hadn't bothered telling him this had happened.
Yeah, and just to pause there, I mean, if a document came in and it was, let's say even in a criminal trial, we have, I'm sure you have it everywhere, but we have what we call a proof of evidence, which is between the defendant and the lawyer, and this is exactly what they say happened and so on. If this was inadvertently, for whatever reason, sent to the wrong party should look at the title of it and immediately see that it's not for them, it's privileged, they shouldn't look at it, and it would mean they have to withdraw from the case and so on and so on. So they just shouldn't read it. So, I mean, most lawyers would probably withdraw at that point anyway. But if it were accepted that they didn't look at it, didn't read it, and never referred to it and so on, and it might get away with it. But that's another thing. So just if a document is so marked as privileged and it's clear and they just shouldn't be looking at it, that's usually a different matter. This wasn't that. This was effectively a thumb drive, wasn't it, with 3 gig of emails on it.
It sent the Dropbox link for their own internal use. Yeah. So anyway, so they made this application and said, look, they said, we want this back. And what the judge said was, no, just sending an email saying, please disregard. Mm. And he couldn't deny that he knew what the rules were because he actually quoted them in his motion. Yeah. But they said, look, it's a very strict procedure because you haven't identified why these documents are privileged. Now, remember, these are the documents they claimed did not exist in disclosure. So what's going to happen after that is going to be interesting. Anyway, the judge actually did belatedly give them a belated chance to actually put a formal objection and say why it's all privileged. Now, just so we can do one of our little predictions as to what's going to happen, I will predict now that the judge will say it's too late. You've waived the privilege in the legally privileged documents. However, there were also some confidential documents in there, such as medical records of victims and things. I think the judge will say, yes, those should actually remain confidential, not least because upon receiving these documents, the family's lawyers went through them, obviously. They spotted those and they, of their own volition, deleted anything that they thought was sensitive. And they let the lawyers acting for the families in the other trials that this material related to, they said, look, we've had this sent to us, we have destroyed it, but just so you know, because this is interesting, saying, just so you know, Jones's lawyers already have this material, even though they shouldn't have it yet, because you haven't gone through your disclosure system, and these aren't the lawyers on record. And obviously, stuff like psychiatric reports and medical reports of victims are not to be disclosed to third parties. So that's another thing. I mean, this is going to be... The judge has said, because it's been so touchy, she said all the sanctions arguments and sanctions where you say the other side's lawyers should be penalised because of their conduct. She said, we'll just deal with that at the end of the trial because there's been so many. And what was fantastic is, I think the judge was channeling Bender from Futurama, because when... Jones's lawyers made this application, and they said we're asking for a retrial, and she laughed. And she went, I said, oh, you're serious? It's like she goes, well, let me laugh further. No, she goes, this is isn't like your 17th request? I mean,
it's also a bit like we've had that, or certainly I've had this in real trials where. You see, well, to explain this, there's a bit of it's a tangent with a bit of a backstory, so bear with me, but it's interesting nonetheless. So every time someone asks, a lawyer or a litigant person asks for something in a court, they're asking the court to make a decision. So the court needs to make a decision, and by making that decision, they will, if they entertain it, usually, they have to take representations from the party that makes the application and the opposing party to say why they usually object to the application, because there's very few things. If it's an inconsequential administrative change to a particulars of claim or whatever, then they'll just say, yeah, we agree that that's clearly a 9 and not a 7 or whatever. But in doing so, the court must go through this whole process, and sometimes it's a little, well, it can be indicative sometimes when the court has to go through this motion of deciding, or at least pretending to decide when it's actually clear what the court was going to do anyway, deciding on this application. So there are some times when the judge will turn to you when you know that what the decision is going to be, and say anything else I need to hear from you, or it just indicates the judge has made the mind up already, but has to go through these motions. So that's a bit like that, with the retrial. It's like, let me think about it. No.
Well, this judge has been brilliant, because there's one where it just goes, object, it just, no. Because it's just like, I need to hear it. And what was interesting is he actually said he referred to his motion. And he said, well, of course, I referred to sort of, the court's motion of so-and-so. And she said, no, you don't understand. When you ask me to do something, it's a motion. When I tell you, no, I'm not going to do it, it's an order.
It's an order. It's not as I often say to people, it's not a conversation. A lot of people seem to think that these applications and arguments to the judge is some sort of conversation, but it's not quite how it works. As I said, it's easier to think whenever I explain, particularly to usually to lay clients being not legally qualified, how this all works. I say, when you go to court, whatever you go to court for, you're asking the court to make a decision. And this is the best way, even in a criminal trial where you've got a judge and a jury, you're still asking the court to make a decision. It's a guilty or not guilty decision, and it's made by the jury, the finder of fact. The judge is the finder and the control of law and evidence. You're asking the court to make this decision. If it's a decision of law, a question of law, the judge makes that decision. Of course, you don't ask the jury to make that. Although there are certain findings that meet certain tests within the law that you do ask the jury to find, but you ask them to find it as a finding of fact, which is underpinned by law. And so it's not a conversation. It's not a case of let's chat it out. The judge will hear the arguments and decide, really, as to. Sometimes it's just a ruling for the ruling's sake. Sometimes it's a decision based on the strength of the argument. So I've had a lawyer opposing me saying this is the paradigm case where this should not succeed, and I'm thinking it's the other way around. It's a paradigm case that this should succeed. It's literally written in the law that this is a right. People have a right to something. Anyway, I digress. But again,
it's funny you say that, because I always do when I do the advocacy training. I always say when we do the narrative advocacy, that's where you're addressing the judge like you want an application or an injunction. I actually do say I said do it as a conversation. Just
yeah.
I always do my
but that's different though. That's when you're teaching someone how to do it rather than understand the process of what it is, because. Actually, the reverse is true as well, and you're absolutely right. When I do, you do it at the inns, I do it at a law school, but the same thing. I mean, students tend to go for this legalese and try to flower it up, and actually a lot of people expect that. And some people then say, that just seemed like a very brief conversation between you and the judge. And it's not a conversation, it's legal argument. But
use plain English. That's the thing.
Use plain English.
I always say, don't try to sound like a lawyer. There's a guy called Irving Younger. He was an American judge. He was possibly the world's best advocacy teacher. And I recommend you just go on YouTube and do Irving Younger advocacy, because he could have been a stand-up. He's amazing. Yeah, he was always sort of. I've completely lost my thread now, because I'm talking about Irving Younger. No, he was also saying about using plain English, because he said, he said when I started out as a new judge, he said they stick you in traffic court. He was in New York, so they just stuck me in traffic court for 2 years, like night court. And he said, I was in traffic court for 2 years. I probably heard 2 or 3 cases a day. He said, in all of those thousands of cases, never once did I hear a lawyer use the word car. It's a really good point. He said, it's always. In what manner were you operating the motor vehicle? And he said, how were you driving?
Just before I give, I'm going to put in the chat here by this, and there's a book for anyone who's interested in advocacy and how advocacy in court really works, how it should work. This is a fantastic book called The Devil's Advocate. This is, I would say, this is. Not quite, but almost a replacement for all of the advocacy training in a law school. It's fantastic. And obviously you don't replace the advocacy training in a law school, but this is almost a must read. But now I've lost track of the story I was going to tell you now. What was the last thing you just said, Al? You were talking about...
we were just talking about using English. And please don't replace advocacy training, because I like going up to Cumberland Lodge.
No, absolutely. I love the advocacy training. No, I've lost track of... story I was going to tell you, but I can't remember what that was now. Yeah. So you said in a motor court, never use the word car once. Interestingly as well, this is the story, I remember now. So you have to get into evidence everything upon which you rely. So if something is not in evidence, you cannot rely on it. So for a prosecution or a claim or whatever, defamation perhaps, or whatever it might be. And we'll come back to these emails in a minute, I promise, but because these are in evidence, obviously. So this is why it's relevant on a tangent. But you have to get everything in. I can see your test message in the chat box, Al. You have to get everything in as evidence. Otherwise, you cannot rely on it. If you can't rely on it, it's not evidence, doesn't form part of the case. You cannot succeed on something that is not in evidence. So in this very brief case, too late. But in this very brief case, the name of the defendant was never actually formally entered in evidence. They're referring to this man, this defendant, the car, and none of it formally identified in any of the evidence that this was the person driving the vehicle. And so the submission of a no case to answer, of course, once the prosecution case had closed, was there's no formal evidence that links this defendant by this name to this vehicle. And so the case had to disappear. Anyway, that was the short story. So everything's got to be in evidence. So speaking of being in evidence, and we come back to these emails and the rules that surround them.
Well, what's very interesting is, because as I said, like all these law enforcement agencies wanted them, including the committee looking into the January the 6th events, at the Capitol. And actually, it was always interesting. So we've had a request for this, and the judge said, well, I don't think I can refuse. You can't refuse that request, regardless of what I do, because Congress can subpoena this. And immediately after the ruling had come back, where the judge said, "For the time being, I'm not going to interfere. You've got them. If the other side can put together some sort of argument, I'll take another look." But the January the 6th committee have got them. And what was also interesting is they left a hot mic on after they closed down the live stream after this application. And you could hear Jones's lawyers, and they were talking about, the fallout from this is going to run for months. Because, he's a very influential figure. And there's, the thing is, there's going to be, texts from senators on there, from politicians, from other media figures. Because this trial did show a lot about how InfoWars works. And what was interesting is that their defense strategy appeared to be just admit everything in terms of how they operate. It's all like, you don't check the veracity of any of your stories, do you? No. You just put like the worst headlines up there that you can. Yeah, it's called clickbait. It gets lots of views. You just want to attract lots of viewers. Yeah, because just to sell your stuff through the shop that you've never tested. Yeah, that's right. So it's your defense, basically. You are allowed to defame and harass grieving families and profit on it. It's like, well yeah, it's the Constitution. So it was like in The Simpsons where Mr. Burns can never see why he's done anything wrong.
Yeah, exactly. And so the question here, spoken evidence is hearsay, ? Well, hearsay is very easily defined, really. Anything that is not said in oral evidence, in other words, is not said by someone who is in court. Anything not said in oral evidence that seeks to prove the truth of the matter stated or to cause a person to believe or a machine to act upon the basis that the matter stated is true. So if you just want evidence that it was said and not the truth of it, there's not hearsay. But if you want to prove that what was said was true, or what was written, or the picture, or whatever else was true, if you want to prove that it was true, but it's not in oral evidence in court, it's hearsay. So hopefully that answers the question. So the emails, and we have rules about this, of course. So we started off by saying we've probably got 15 minutes to wrap this up, Al.
Okay. But let's come to the CPR then, because people love the civil procedure.
So yes, let me just double check that we've got this on the correct screen. Yes, we do. Hopefully, back to live mode. There we go. So, false disclosure state 3120, just above there. Hopefully, you guys can see that. I can zoom in a bit and it makes it bigger. There we go. So, restriction on use of a privileged document, inspection of which has been inadvertently allowed. So, that's lawyer speak for someone's been able to look at something they shouldn't have looked at. That's privileged.
Restrictions on when you accidentally email all your incriminating documents to the other side.
Oh, yeah, that's another way of putting it. You see that box of files over there? Well, that's all the stuff that we didn't want them to see, but we've just sent them a copy of it.
Well, like I say, because it's it's the whole thing when we did this disclosure form the other day, and there's the box where you say we've got this, but you're not allowed to have it, or we don't have that. So that's what they'd filled in, and then it turned out yes, we actually do have it. But this is interesting because it seems like a really straightforward rule. Okay, and I'll let Dan read it because my eyesight's not good enough. But I think it's when a party inadvertently allows a privileged document to be inspected. Yep. The party who's inspected the document may, and I can't read the rest of it, may not use it.
Yeah, may use it or its contents only with the permission of the court. So let me zoom in a bit more, so hopefully it comes it. So only with the permission of the court. So another way of putting this, a private document that someone's been able to see that they shouldn't have seen can only use it with permission of the court, or the contents. I mean, that's important because it could be, a picture, a graph, a statistical analysis, or an audio recording, so you can only use it or its contents with the permission of the court.
Yeah, it's pretty reassuring, isn't it, to everybody that, we have a procedure for this. But what's interesting is, and just to explain, the civil procedure rules, they're put together by a committee of judges, and they're just basically the rules for how we operate the courts. But the civil procedure rules cannot overrule the actual law, whether that be statute or common law. And sometimes there has been clashes between them where people have said, well, the civil procedure rules say this, and the court judges have said, yeah.
These are the civil procedure rules. It's like Star Wars, isn't it?
That's why I've got them as PDFs.
Yeah, I mean, these sit on the shelf to look pretty. I use it online now, but back in the day when I used them, obviously we got and this is not that's not
just volume one.
This is volume. Yeah, this is not thick paper either. This is like literally it's monsieur, it is wafer thin. And
wafer thin about.
And don't you think it's interesting when we get told off, or we get documents or cases thrown out because we use the wrong font size, because it's supposed to be, what is it now, 12 in certain courts.
Which is 12 point double spaced.
But look at that. If I can get it closer, you can see that is not size. That's not size 12. That's like 7 or 8, if that.
California's gone up to 16 point now, so not 14 point. So 14. They're obviously
wow.
Eyesight is obviously it's all like sunshine. But yeah, and it's really weird. And what we said before, courts have rejected documents because they're in the wrong font, and then people like cases, multi-million-pound cases, struck out because they didn't. You said, well, you didn't file it. And they said, we did file it. Said, yeah, it's in the wrong font. It doesn't count. But anyway, what's interesting is there is a bit of a tension here between what the CPR says, because the CPR implies that, well, you can't really use it unless you get permission of the court. There has been some common law on this, and some cases, and uncharacteristically, I actually made some notes on this. What they said is they gave various guidance about this and said, well, privilege actually belongs to the client. It's the client who has privilege, and lawyers generally can't waive privilege on behalf of their clients, which can be a nightmare if you're in a wasted costs application where you can't sort of say, well, my client told me to do this. Is why I did this, because my client told me. The client, and it also helps in negligence claims because the client has to waive privilege. But they've said a solicitor actually has the ostensible authority to waive it. So even though a solicitor can't waive privilege, ostensible authority is where you actually don't have the authority to do something, but somebody could reasonably think you do. Things. It's something like ostensible agency. What's interesting is a solicitor who gets a document, a privileged document, you don't owe a duty of care to the other side, okay? And you're allowed to start by assuming that they meant to do it, that privilege has been waived. And generally speaking, if you've disclosed documents, it's too late to then rush off and get an injunction, because we were saying the other day about injunctions, they won't act in vain, the cat's out of the bag, etc. But again, we did actually say sometimes there's that tension where the court will say, well, even though it's out of the bag, I mean, you could make an injunction to hand it back, of course. The court is allowed to say you can't rely on the mistaken disclosure, and the test is, quotes, where justice requires, which is, nice and nebulous. The court will look at all the circumstances about the disclosure and how it happened. And one thing they are allowed to look at is, and again, quotes, where the disclosure has been, quotes, the result of an obvious mistake. Okay? And they've also said is, when you're looking at this, you've got to sort of go, what did the receiving solicitor think themselves? Did they realise this was an accident, or did they we'll assume it's been waived? And then what would any other lawyer think? It's this objective test. If somebody was looking from the outside, would they say, actually, they clearly didn't mean to do that? And they do those together, though, because one of the bits of evidence they use for considering what a reasonable lawyer would think is, we're all reasonable lawyers, and we thought it was okay. But they do accept. And some more things that they came up with. And they said, look, now we've all moved to electronic disclosure, emails and Dropboxes and things. This thing's happening more and more. Although it used to happen, even I've received documents from lawyers where they've clearly just had them on a table, stacked them up, and picked up 2 cases by accident, put them in the same envelope. And you read through and you go, what's all this stuff at the end for? That means, I mean, and I don't know if you have to say this, but a particular solicitor sent me some material relating to a very, very high status client down here. That's all I'm going to say. And I literally did the thing. It's like, do this. And I emailed them straight away and said, I don't think you meant me to send this. I've put it through the shredder. Because I read the cover. Yeah. I did actually have the cover sheet, a couple of pages in, just to sort of see if it did have anything to do with it. And I go, hang on, I just don't understand this. Have I missed something? And it's like, this clearly wasn't meant to be sent. So I did drop them an email, and they were like, yeah, that's brilliant, thank you.
Well, that sort of matches up with what Miles Heffernan, thank you for the very generous super chat here, matches up with what you've just said, Al. Thank you, first of all, saying that you love our content. We love to bring it to you. As you can probably tell, this is a bit of a passion of ours. In Australia, if a lawyer accidentally sends material to the opponent, it has to be deleted and never spoken of again. Is it really the case in Texas that if you screw up, you have to particularize documents? So I think that the issue here really is, well, it's twofold, isn't it? First of all, particularizing which ones were privileged and which were not, because there is that argument. I can see the argument that even in our rules, it speaks of, if I go back to bring the rule back up again, your super chat should stay on screen, albeit slightly obscured. I'll move it to there. I'm still getting used to this software, forgive me. But even in our rules here, it does talk about a privileged document. So if you were to interpret these rules, where a party inadvertently allows a privileged document to be inspected, the party who's inspected the document, blah, blah, blah. So the argument there is, if the document is not privileged, it's just a document and you've sent it, then it might be inadvertent disclosure or inadvertent inspection. But if it's not privileged, that's not caught within this rule. So I can see the argument. So by particularizing the documents and saying, well, these ones are privileged, these ones are not. And so that process stands to reason. But also, I recall the lawyer making this argument saying, it wasn't obvious that these were privileged, or which were privileged, if I remember that correctly. And you were going to say something else about that, I think, Al, about the rules in Texas.
Just to say, that is a very strict procedure in Texas, which is, like I say, within 10 days, effectively repeat like we've got those disclosure forms we looked at. It's pretty much do that exercise again. Say, here's all the documents you've got, here's all the various classes, these are privileged and you can't have them, these were non-disclosable, these are confidential for other reasons. But they would have to, part of doing that is actually we have no grounds for claiming these other documents back. It's like leaving on the bus. It's like tough. People are going to read them. So that's the Texas rule. Over here, now, one interesting thing there is they have all these, because it says there about without permission of the court. However, over here, they were very strict. They actually said, basically, if this actually happens, and you need to sort this out quickly, and the sides should cooperate. They've said you should act honestly, even if it would be to your advantage not to. You could benefit a client. And what they really, really emphasised was it should not be necessary to get the courts involved in these disputes. Yeah. Use some common sense. The court would. So unlike in the States where there is this procedure, and it's it seems quite common to always have promotion. Yeah. Over here, they're very much sort it out yourselves. You all.
Just on that note, here's another story. I couldn't quite believe this came out, but it did. And this is not a criticism of the court system. You understand? I'm obliged to say that, but it's a fact and it's a public record, so I can tell you what it said. But during the pandemic and the lockdown and everything was locked down, and to begin with, all the courts just went into complete lockdown apart from those emergency ones. It was like, no, we really, 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 really have to hear these cases right now. So they continued. A lot of the rest of them, and in fact, one in particular, it was a very small claim that I was involved in. And the order from the court came back and said, we don't have time to hear this. Sort it out yourselves. That's literally what the court order said. We've looked at it, and you can imagine the judges obviously looked at this and just thought, you don't need the court to sort this out. Sort it out yourselves. And it sent the order. It just literally sent the order saying, we're not dealing with this. Like, unheard of. Never seen it before. I doubt I'll ever see it again. But wow, yeah.
No, I've had an order recently that says the judge wants. We have to record, because we were saying about all the without prejudice stuff The judge has said, if anybody makes an offer and it's refused, the other side have to give full written reasons, and I want to see these after the trial. So it's basically going, I am banging your heads together now, and I will. But I've had this before. Actually, I had a judge once. We had a silly row, and the judge said, go outside. And he literally said, go outside. He said, I just want to address the lawyers on their own, just housekeeping. He said, right, you two go outside, bang their heads together, and settle this. He said, if you don't do this, I will somehow find a way of penalising both sides in costs. It's like, okay. Then it was, it's like, then you have to go to your clients and say, the judge has given us some indications, and, he really sees your side of it, but, it's always a risk, chance to sort this. But judges, especially in the busy courts now, they are encouraged to be a lot more activist in case management. As that quote you go, in the old days, we just provided the pitch and the referee and let the parties play whatever game they wanted. That's not the case now. They step in. It's all about this diverting things away from trial. There's going to be more compulsory mediation coming in. Let me say, very few issued claims actually get to trial, and they're trying to reduce them because there's a horrendous backlog in the courts as part of anything else. And little what we call satellite litigation, where people aren't even rowing about the underlying matter; they're rowing about some procedural aspect. Courts really hate that, discourage it, because while we're rowing about whether an email should go in or not, there's somebody waiting for their emergency non-molestation order. So that's the sort of rationale behind this. But anyway, that's just what's happened. So that's what's happened in the Alex Jones case, and perhaps we can talk on another occasion about, because the damages aspect and how they do punitive damages and how we do aggravated damages, and the difference in the culture where American damages are effectively, there's a penalty, a punishment element built in, whereas in England and Wales it's meant to be that they are compensatory only. So it doesn't matter how evil somebody's been generally. You only get what your loss is. But there are exceptions to that. We do have exemplary damages and aggravated damages.
Your general and special damages are split out, and so this is generally, think of it as, I don't know, you either trip up something because someone was negligent, or you're hit by a car or something else. And so you've got essentially two different types of losses. One is something that you can just materially replace, such as your clothes and the car and whatever it is. The other might literally be your injury to feelings and the discomfort and the distress that you've had, which is not a monetary. You can't buy it or replace it, but it is a compensatory type thing that's embedded within the whole process. And then, of course, there's the costs of fighting the whole thing, and this is where it gets really, really outrageous. And the costs and the penalties within those costs and the cost rules really encourage lawyers and all parties to run the litigation properly, because you obviously get punished by way of costs, which you obviously don't get apart from your interim sort of motions, motions in limine and seeking costs orders for. So if someone makes a really silly application which should never be granted, should never been applied for in the first place, then you can be sure that there'll be a cost application on the back of it. But the average, I say average, there probably is an average. I said the average, not sort of non-fatal, not particularly serious road traffic collision, personal injury in the value of £1 to a few £1,000s of personal injury. The legal costs on each side are probably 10 times that. Really, it's just it's outrageous. And you'll get my experience is that big companies will spend tens of thousands of pounds to defend a claim for 1,000 or 2,000, because they're not really defending. Of course they are defending, but they're not really defending the claim and the thing itself. It's more the principle, because they don't want floodgates of we get known as a company that settles and we pay this out. Of course they don't want that. They'd rather fight it. They want the reputation of, you sue us, we'll fight you, and we'll fight you hard, and that's what most of them do. But of course then you've got the the amount of times I've seen harsh emails and really critical, unnecessarily aggressive exchanges, which just not called for, because particularly as I'm sure Al will agree, and that we can say this, but as barristers, we try to be just very straightforward, almost cold and calculated in the way that we do things, because there's no need to be anything else. And, you know, I say the only time sort of opinions and emotions come into play are opinions when they're an expert one, or feelings when it's actually relevant to the case. Like you've difference between a simple theft and a robbery might well be the fear of violence, and so that's where your fear and your emotions come in. Otherwise, with respect, no one cares how you feel about it, and so we try to stay quite straightforward on that, don't we, Al? Really?
Well, also what people forget is, because there is definitely a culture where barristers tend to be a bit more cooperative with each other because we're a bit more detached from the clients. But also, one aspect of costs is there's something called a wasted costs order. Yep. And that's a cost order made against the lawyers. Mm-hmm. They can sort of say to us, right, had you have lent on your client to say this is nonsense, you wouldn't be wasting all this, you should pay for it. So if we ever come back and say, that's a bad idea, we're not going to do it because it's an abusive process, or that's why we do it, because if we allow you to do something, we can end up picking
it can bite us. The amount of law students that are amazed at that fact, they look at me and, really? Yes. You can personally be made to pay these costs. It's amazing.
And we get back to the waiving privilege point, because one thing that on the wasted costs application, courts are told that, remember, it's up to the client to waive privilege. The lawyer can't waive the privilege and say what the background to it is. And you must bear that in mind. And it's almost like a sort of, you have to give them the benefit of the doubt if you don't know what the background is. So actually, you don't. Sometimes you don't want your client to waive privilege. I've only ever faced one wasted costs order, and it was a really confusing one because we got all confused as to why it was my fault, and then we realised actually it was something that happened earlier in the case when it wasn't me doing it. So I was going like, I don't have to defend this. Why is this my fault? And then we're looking at it a minute. I didn't do that hearing.
Yeah, no, yeah.
I think that might be why I got sent to do the next hearing. Actually.
Yeah.
Okay.
So there it is. I hope that was a useful explainer. We were going to do this as a 15-minute pre-record. We've turned into a good 45-minute chat about it. I hope it was interesting. I hope it was entertaining in some sense. There's a few things that we'll touch on. We'll come back to. Thank you particularly for the super chat and your questions and your comments. Any closing thoughts, Al? And then we'll come back and do, I think, more in depth on those other issues.
No, just that. We must remember that this general thing about looking at trials and the real tragedy behind them. This is much as this case has been spectacularally amazing to watch. Fundamentally, it's based on a horrible, horrible tragedy and people suffering. So I do remember that. But having said, it's just been an amazing exemplar of. Somebody actually said it was like law students could cover every single topic just by watching that case because it's got perjury, defamation, costs. And I actually said, actually, there's still time for it to cover assault and battery because I think those lawyers might have he's going to kick off again. It's done. The thing about these cases is they do allow us to talk about these general principles, so you understand the law, but also just how things happen in the background. So, like I say, now when people are discussing this. If people are saying, it must be a conspiracy, no lawyers are that stupid. Like I say, that reflects very well on us as a profession, but I think we really need to work on some expectation management.
Yeah. Next video, expectation management. What to expect from your lawyer. And with that, for me, that was what we wanted to talk about. So there it is. Thank you for watching. Please like the video on the way out, as you did on the way in. And thank you all very much for your time. Thank you for watching.